Let's talk about two rulings in one day. One gives the president the green light to take command of a state's National Guard, and the other could decide whether using marijuana, even legally under state law, is enough to strip someone of their Second Amendment rights. They may seem like different stories, but they raise the same question. When power says it's acting for your safety, how much proof do we require before rights are pulled back or force moves forward? Let's start in Oregon. A federal appeals court just said President Trump can federalize about 200 members of the Oregon National Guard to protect a federal building in Portland. The building in question is an ICE facility that's seen some protest activity in the past. The panel stayed one court order that had blocked the federalization, but a second order focused specifically on deployment is still in place, at least for now. The DOJ has already moved to dissolve it, and the court hinted that both orders might stand or fall together. Oregon is asking for a full on-bank review. The state argues that protests have quieted down, and the administration says threats remained and points to recent incidents near the site. Now, shift to Washington. On the same day, the Supreme Court agreed to hear United States v. Hemani. The question is whether the federal government can bar people from owning guns just because they use a controlled substance, even if it's legal under state law, and even if they're not under the influence at the moment. The law known as 922G3, targets unlawful drug users. That means ongoing use, not just isolated incidents. The lower court said that sweeping rule goes too far, and the government wants it reinstated, arguing it matches a historical tradition of keeping arms from dangerous people. The court will now decide how far back we go, and who counts as the people the Second Amendment protects. In Oregon, the federal government wants control of state forces to protect a building. In Hemani, it wants to restrict a right based on a citizen's status. And both claim necessity, and both say it's about safety. But in a constitutional system, safety isn't a blank check. It's a claim that has to be justified, measured not just by danger, but by the response. The founders knew the pull of fear. Hamilton warned of what happens when military power rises above civic life and civil life. Madison designed a system where no branch or level of government could move unchallenged. He called it ambition checking ambition. That design is being tested right now. If the Guard can be federalized more easily, your local balance of power shifts, even before a single truck rolls. If the court rules that a drug use label is enough to remove rights, millions of cannabis users, that are lawful under their own state law, but not federal, could be affected. So here's the question. When fear is the reason, what kind of proof should we demand before a president gains power or a person loses their rights? And who do you trust to draw that line?